Good afternoon, everyone. My name is Madhusudan, and I welcome you to this polity class of N100 series. In this series, we are discussing complete polity from the mains perspective. In detail, we are taking up those topics which have very high probability of being asked in the civil services mains examination. In this series, we have already completed a lot of important themes related to, say, preamble, fundamental right, fundamental duties, then legislative, executive, judiciary. Now we shall move towards the another section, and another important aspect in UPSC mains is election. And in election, obviously under the constitutional body, election commission is important. Apart from that, representation of people act is a specific topic which is mentioned. So in today's class as well as tomorrow's class, we shall look at the various aspects of election, including representation of people act. Okay, so very good afternoon, Manoj. All of you who have joined the class, please like the video and share it with your friends so that they can also join it live, and we can discuss their doubts. That could be a very good learning for you as well. Okay, so let's see. The first thing which was in the news, which was related to constitutional provision related to election, and from here we shall move towards the provision related to appointment of election commissioners. That is something which is very tedious, or rather very much debatable. See, one more thing that you need to understand why we discuss about the appointment of election commission or removal of the election commission is because election is central to the democracy. Like whenever this question, like we very proudly showed the world that India is the largest democracy. What is the basis of India being the largest democracy? Because the number of voters that took part in these elections are the highest in the world. We call ourselves democracy because there is peaceful transfer of power every 5 years. Because there is regular election which is conducted and which is by and large free and fair in our country. Because of these reasons, we say that India is the largest democracy. We take pride in that. We shall in tomorrow's class see that how there are certain small loopholes in our story or our proud story related to election and democracy. They're relatively small, but obviously even those small loopholes need to be filled. So let's start it with the first, the constitutional provisions related to election. What does constitution say? So the first is article number 324. Few of these articles, I would not say that all the articles that I will show you on the board you need to memorize, but at least you should have an idea. Let's see, after article number 324 we have provisions related to election, election commission, etc. It will help you especially in prelims exam. And this article is important, 324. Okay, it's like unlike 1 2 ka 4, it is 3 2 ka 4. That is election. Okay. Next is this article says the superintendent direction and control of elections to be vested in an election commission. This article prescribes for an election commission of India to conduct elections of Lok Sabha, Rajya Sabha, a state legislative assembly, a state legislative council, president, vice president. The election of all these bodies are conducted by Election Commission of India. We do not have a separate election commission to conduct election of a state legislative assembly or legislative council. Both are conducted by the same Election Commission of India. The Supreme Court has also interpreted, I will come again on this article, but Supreme Court has interpreted that Constitution has given plenary power. This is the word that is used. Plenary power to Election Commission of India under this article. What is meant by plenary power? Plenary power means there is a reservoir of power, that is unlimited power, and using this reservoir of power, whichever power is required to ensuring free and fair election, for conduct of free and fair election, whatever power is required, that is found in Election Commission by virtue of Article 324. So, Election Commission is not dependent on Parliament to legislate to provide certain power to the Election Commission of India. If Election Commission of India feels that it should have a particular power, it has it. It's as simple as that. That is what Supreme Court has interpreted. Next is article number 325. It says that no electoral roll on the basis of religion, race, caste or sex. In other words, this article says that there is going to be one single electoral roll. See, one single electoral roll does not mean that there is going to be single electoral roll for Lok Sabha, Rajya Sabha, SLA, SLC, President, VP. It simply means that for any particular these elections, let's say election of Lok Sabha, let's say election of state legislative assembly, there is going to be one single electoral roll. There cannot be one electoral roll for upper caste, another for the lower caste, another for the scheduled caste. There is going to be one single electoral roll. Okay, and this also provides, like, from this article, the right to vote emanates. These two articles together, 325 and 326, from these two articles together, the right to vote emanates. That's why in prelims there has been question, the right to vote is a fundamental right or no? Answer is no, it is not a fundamental right. It is a constitutional right, which can also be termed as legal right. So more technically, it is a constitutional right. Sometimes they will write it as a legal right also. Article 326 talks about adult suffrage. Everyone who is above the age of 18 years of age is eligible to be included in the electoral roll, and once you are including electoral roll, you are eligible to vote in the election. Okay, and by 61st Constitution Amendment Act in 1988, the age limit has been reduced to 18. Original constitution had given age limit as 21. So now we are becoming adult at a relatively younger age. Earlier, like our previous generation, used to be adult at a relatively later stage. We are maturing fast now. Okay, this is something like next generation is even maturing even faster. Maybe it needs to be reduced further. These generation kids, like, they are probably they are born with this genius of using a smartphone and all those things. Next is article 327. This two article 327 and 328, they give the power. Obviously, all the provisions related to conduct of election cannot be written in the constitution itself. So it has given the power to the parliament as well as a state legislature to make laws. But these laws would be subject to the laws made by parliament. And exercising this power under article 327, parliament has made two laws, Representation of People Act 1950 and Representation of People Act 1951. Now we had studied doctrine of occupied field. Under that doctrine, it is said that if a field is already occupied by the center, a state cannot make a law on the same field. So since center has already occupied this field, the parliament has already occupied this field, none of the states have made law for themselves. Earlier Jammu Kashmir had its law, but now that I mean, even Jammu Kashmir did not have this law, sorry. So none of their states have made laws under this article, although they are eligible to make laws. Okay, states have made laws for the local bodies election, but that is not under this article. That is under separate article. Okay. There is also article number 329. We shall study that as well. Some of these articles we are going to study in more detail. For example, article 324. Article 329 says that court cannot interfere in the conduct of election. So when election is being conducted, now no one can approach the court that see something wrong is happening. Once election is complete, then only someone can approach the court through something known as election dispute. This is a very mature provision of our constitution. Suppose it was not there, everyone would have approached and the election would have never completed. It is same thing like saying the way like a UPSC and a state PSC elections, sorry, a state PSC exam. Most of the state PSCs are not able to conduct the exam within 1 year time period because of the fact that there is very frequent court interference, and obviously for the good reason. I am not saying that the court should not interfere because they are not efficiently doing their work, but UPSC manages to conduct the examination, civil service examination within a year because the courts have till now desisted from interfering in the declaration of result by UPSC. Whereas in case of state PSC, people often go to the High Court. High Court gives a stay order, then the new result is published, and then it keeps on happening. Okay. Like in the state of Telangana, since the state has come into existence, it's been more than 10 years now. There has not been a single exam for the State Public Service Commission. By single exam, I mean all three phases being completed. Sir, as per Article 328, can a state make a law for Lok Sabha election? No, a state can make law for its state legislative assembly election. But that too has not been made by any of the states because Parliament has made law for the state legislative assembly election also. This Representation of People Act 1951, it covers both Lok Sabha election as well as a state legislative assembly election. Okay. Now the recent thing which was in news was related to the appointment of election commissioners. This was the government has brought this act, Chief Election Commissioner and other election commissioners appointment, conditions of service and term of office act 2023. Very big name of the act. You can simply remember Chief Election Commissioner and other CEC and other EC Act 2023. This is relatively easy. CEC and other EC Act. Now, why this act has been brought? Because of a Supreme Court judgment in a case named Anup Barnwal case. Do you remember anyone? What was the judgment of Supreme Court in this Anup Barnwal case? Let's look at the provision of Article 324 Clause 2. Article 324 Clause 2 mentions that the election commission shall consist of chief election commissioner and such number of other election commissioner, if any, as the president may from time to time fix. So, how many election commissioners would be there? It would be fixed by president. Please tell me, who fixes the number of judges in Supreme Court? We have discussed it in the topic of Supreme Court. We have discussed it. Please tell me, who decides the number of judges in Supreme Court? Number of election commissioners is decided by president. Yes, you are right, Manoj. It is the parliament that decides the number of judges in Supreme Court. Okay. Now let's come back to this article. And the appointment of chief election commissioner and other election commissioner shall, subject to provisions of any law made in that behalf by parliament, be made by president. So in simple terms, appointment of election commissioners will be made by president, subject to the provisions of any law made in that behalf by Parliament. So, if Parliament makes any law, as per that law, the appointment shall be done by the President. This was the article. Parliament did not make any law for the appointment of election commissioner. So, effectively what was happening, that President was appointing the election commissioners and chief election commissioner. The matter was simple. But now people approached to the Supreme Court because people were their basic presumption was that government was appointing its favorite in the post of election commissioner. Okay, this is again we are saying that this was the apprehension of the people. This was the accusation of the people. We are not saying that see those who have been appointed as election commissioner, they are biased towards the government. Okay, this was the accusation that people were making in the court. Let's see, effectively, election commissioner is someone like umpire. Like in a cricket match, there is two team which is batting. The umpire now it is a established practice that in an international match there is going to be a neutral umpire. If say India and Australia are playing a match, the umpire would be from any third country, maybe England, maybe Pakistan, maybe West Indies, South Africa, but not from either of the two countries who are playing the match. Okay, why? Because when it was seen that when earlier the umpires were from the either of these two countries or from the host country, there used to be a lot many decisions which used to be like biased in nature. The umpires had a tendency to give judgment or decisions in the favor of the country to which they belong. So then this convention is developed that now we shall have independent umpire. See, do not come with any explanation that see, sir, there was a Steve Buckner who was although neutral, but still his judgment used to be often against India. Let's not take those examples, but this is the principle that we are now following. Similar principle people argued that should happen in case of election commissioner also, because election commissioner is effectively also umpire. The political parties are playing a match between them. Since election commission is umpire, umpire must be neutral. And a neutral umpire cannot be appointed by one of the parties. When president is appointing, effectively president is appointing on the ad and advice of PM and his council of minister. So effectively what PM is again going to contest the election, PM has to necessarily contest the election. So effectively the captain of one of the team is appointing the umpire. There is very little chance that that umpire is going to be very what do you say, unbiased in nature. Why would I appoint an unbiased person? Why would I not appoint my favorite if I have to appoint an umpire? If I will always have someone who is favorite to me. Okay, so this is something which was happening. People like in this Anup Pandwal case, people argued that the umpire should be neutral. Then Supreme Court said that the constitution wanted parliament to make a law in that behalf. Okay, and since parliament has not made a law in 7 decades, it is the duty of the Supreme Court to fill this vacuum. This is again another example of judicial activism. Okay, the Supreme Court did not restrict itself to a mere understanding of the wording used in the article. Supreme Court said that the constitution wanted parliament to make a law. Since parliament has not made a law, now it is the duty of the court to make the law. And court said that the appointment shall be done by a committee consisting of Prime Minister, Leader of Opposition and Chief Justice of India. So, President shall appoint a person as election commissioner or chief election commissioner on recommendation of a committee of these 3 members, Prime Minister, Leader of Opposition and Chief Justice of India. Obviously, since this committee has a member from both Prime Minister and Leader of Opposition and also it has Chief Justice of India, there was a sense of neutrality in this committee. Well, government obviously did not like it. So, government brought this act to overturn the judgment given in Anup Bandwal case. So the first thing that you can write about this act is that this act was brought to overturn the judgment given in Anup Bandwal case. Now Manoj has a doubt. A committee of PM, leader of opposition and CGI will suggest the name of election commissioner until a law is made by parliament. Yes, 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 you are right. So in this act, the government brought this act. This act was one thing, like this act overturned the judgment given by Supreme Court in Anup Bandwal case. Apart from this, earlier there was an act, Election Commission, Condition of Service of Election Commission and Transaction of Business Act. So earlier also there was an act which was Election Commissioner Condition of Service and Transaction of Business Act. Okay, you need not remember it. Simply, it is very often said that Election Commission Act has been replaced. Now, the word appointment and term of office has been added. Although the earlier act also talked about terms of office, but it's like transaction of business was the word used. Now it uses the word appointment, condition of service and term of office act. Okay, so here in prelims there is a question very often asked that the term of the office is mentioned in constitution. The answer is no. The term of office is mentioned in this act. Okay. Next is the first thing that it says that this selection committee needs to be changed. These 3-member committee, the CJI has been replaced by a cabinet minister. So now the 3-member committee consists of Prime Minister, leader of opposition in Lok Sabha and a cabinet minister. Obviously, there is nothing written that the committee will take decision by consensus. So, if nothing is written, it means that committee will take decision by majority. So, Prime Minister will choose a cabinet minister. Obviously, they will talk in the same voice. So, effectively, the same system has continued that on the recommendation of Prime Minister, the election commissioners are appointed. But still, we will study further that which are the names that are going to be considered by this committee. So for that, the act mentions that there is going to be a search committee, and this search committee will give 5 names to this selection committee. This search committee would be headed by Minister of Law and Justice, and there would be 2 other secretary rank officers. So obviously, these secretary under the Minister of Law and Justice. So here minister has been explicitly put. Normally in a lot of such committees, usually bureaucrats are there, but here the government did not want to take any risk. Okay, so 2 secretaries under the minister, they will decide the name, 5 names. Among these 5 names, this selection committee will decide. Obviously, selection committee has the power to pick a name which is outside the name recommended by the search committee. But search committee can also not recommend anybody from India to be an election commissioner. Some eligibility criteria has been given. The first is that he should have hold a post equivalent to secretary to the government of India. Okay, secretary is the highest post. After that, there is only one post left is cabinet secretary, and then like the chief secretary in states are also a post equivalent to secretary to the government of India. Next is that he should have knowledge and experience in management and conduct of elections. So at some point of time, he must have worked. Usually, this is something that will be there with all the IAS officers. But see, if you really look at the number, there are only 3 or 5 non-IAS officers who are at any point of time holding the secretary rank post in the government of India. All the secretary rank posts are held by IAS officers only. So effectively, the eligibility criteria makes it clear that only IAS officers can be election commissioner. Next is, he should be a person of integrity, obviously. Then about the salary and condition, the original draft of this bill mentioned that it would be equivalent to the chief secretary. However, that has, sorry, cabinet secretary. However, that has been changed, and the earlier position has been brought, like it would be equivalent to the judge of the Supreme Court. So, like the chief election commissioner, his salary would be equal to CJI, and the other election commissioner, their salary would be equal to the judge of the Supreme Court. Do you know what is the salary of the judge of the Supreme Court? The term of office is mentioned that it would be 6 years or the age of 65, whichever is earlier. So if someone has been, when someone was appointed, if he was already 64 years of age, he would be in the office for 1 year only. If that person was of say 55 years of age only, then he would remain in office for 6 years. So which of the two comes earlier, that is the his superannuation from the post of election commissioner. And he is not eligible for reappointment. Like once a person has completed his tenure of 6 years or 65 years, he cannot be appointed again. Now here obviously there is no scope of reappointment, because you have said that someone who has hold the secretary rank people only get the secretary rank in their last say uh, 2-3 years of their service as an IAS officer. Okay, so after retirement, I mean, until unless someone becomes the election commissioner at the age of say 59 or less, he cannot even hope or think for the second term. Okay, but there was other things that should have been there, that we shall talk about. Yes, you are right, the salary is of the judge of a Supreme Court is 2.5 lakh. CJI has relatively higher salary. What are the concerns with the act? The concerns with the act, first thing is that independence of the election commission is compromised. In appointment, like obviously it is the majority of the government in the selection committee. Next is that even in case of the vacancy in the selection committee, suppose like no person is appointed as leader of opposition, or Lok Sabha is dissolved, in that case there is no leader of opposition, then also appointment can be done. So it is clearly written in the act that vacancy in selection committee is no ground for invalidation of appointment. Then the limited eligibility criteria is a problem, because now only, see what can happen, that only those IAS officers who have retired from the secretary rank in last 2-3 years, they can only be appointed. So effectively you have a very small pool of maybe 50 odd officers from which you have to select, and not everyone is willing, like after after working for say 30 years or maybe 35 years in the government, they might not be interested in further working. Okay, so maybe you will have a very small pool of officers who are interested, who are eligible to be elected as election commissioners. And then there is no mentions that whether they can take the post retirement job or not. Now see, this is how there are 3-4 things which are done, or like uh, to avoid or to keep a person in authority as neutral. The first thing is his appointment should be done by a neutral committee. Second is about when he is appointed, his salary etc. should not be controlled by the government. For this, provision is done that it would not varied to his disadvantage. One provision is this. Another provision is done is that is charged on consolidated fund of India, like is the case of UPSC, like in the case of the Supreme Court judges. The salaries are charged on consolidated fund of India. Okay, so that like Parliament do not restrict the salary payment. Then after working of the salary, there is security of tenure. the government should not be able to remove that person. And then the removal process, security of tenure is also ensured through removal process should be independent of the government. It should not be that someone is, I mean, see, governors are there in the office till they enjoy the pleasure of the president. So see, governors are very much biased. They cannot be neutral. So, but if we want election commission to be neutral, we should provide neutrality in all these aspects. But see, that is not enough. It should not be the case that government should be able to offer a carrot to that person. How can government offer a carrot to that person? By the lure of the post-retirement job. This is something which is not there with the Supreme Court judges either. Even it is the recommendation that Supreme Court judges should not be allowed to take any post-retirement job with the government. Okay, so these are the things that should be there to maintain the neutrality. With respect to election commission, neither its appointment is by a neutral committee. Salaries cannot be varied to his disadvantage. That provision is there. But again, it is not charged on the Consolidated Fund of India. It has security of tenure to some extent, that he will be in the office till he attains 65 years of age or 6 years. But again, his removal process is like, especially with respect to election commissioners, the removal process is not independent of the government control. There is very weak protection that has been given. We will see what is the protection that has been given, or if you know, you can mention in the chat. And then he can be offered post-retirement job as well. So this is also not there. Further, in case of election commission, since they are dealing with the election, they can also be given the lure of joining politics. See, there is always this fear of quid pro quo. You scratch my back, I scratch your back. So when you are election commissioner, you help me win the election. And once you retire from the post of election commissioner, I will make you minister. I will give you the ticket from particular constituency. So if someone engages in this kind of deal, obviously that person cannot be neutral. So we should have a provision that restricts these kind of deals. For that, this provision is done that the person would not be eligible to join politics after retirement, would not be able to get any post-retirement job. So if he cannot get a job, the government cannot make any such offer, government cannot do any such deal. Okay, but these provisions are absent from this. And then the election commissioners have not been given the security of tenure. How? President will remove after recommendation of Chief Election Commissioner. Very good, Manoj. So yes, that is the provision which has been done. Let's see what is the removal procedure of election commissioners. So for chief election commissioners, we have the same removal procedure as is the case with the judge of the Supreme Court. That is, a resolution has to be passed in both houses with a special majority. A special majority in both houses. A special majority is 2/3 of members present and voting plus half of the total strength. Both the criteria should be met. Okay, and this is something that should happen in both the houses. But election commissioners have not been given the same security. Because see, this is very difficult procedure. None of the judges have been removed using this procedure till now. So obviously election commissioners can also not be removed if this procedure is allowed. They will feel the security of their tenure. But election commissioners, for them the only protection that has been given is not to be removed except on the recommendation of the chief election commissioner. So it gives a feeling that chief election commissioner is the boss, and till the time your boss is happy with you, you cannot be removed from your job. Don't you get this feeling? But practically, this analogy is not correct, because the three election commissioners, they are equal in stature. Apart from the name that someone is chief election commissioner, its chief is only because when they are having a meeting, the chief election commissioner will preside the meeting. But while taking any decision, it's not that the decision of chief election commissioner has primacy over other election commissioner. If it is the case, like there are two election commissioner currently and one chief election commissioner, these two election commissioner, if they are saying say X and chief election commissioner is saying Y, the X would be the decision of election commission of India. Chief election commissioner does not have any veto power or any special power with respect to other election commissioners. So all of them are equal. Only in case of for presiding of the meeting, etc., chief election commissioner is chief. And then obviously he has got the protection in terms of removal. So in terms of functioning, all the election commissioner are equal. But in terms of removal, definitely chief election commissioner has got the more protection. Okay. Like that's not same is not true with respect to CJI. In case of CJI, we have seen that when in collegium will not recommend a name which is not agreed by Chief Justice of India. So even if say other 4 judges are agreeable on the name of X, CJI is saying that no, no X, then X will not be recommended. So here CJI has primacy over other judges. The same is not true in case of Election Commission of India. Clear? So now we shall see what are the suggestions that we can give. So see what were the problems, you simply remove those problems and that is a suggestion. So nothing much to be studied here. Okay, and so apart from those suggestions that we have given for giving them autonomy, you can always give suggestion that they should be given uh, see their salary should be charged on the consolidated fund of India, that will give them security. The removal procedure of election commissioner should also be on par with the chief election commissioner. So all these suggestions you can give. I am giving you something else, like what is the model used for appointment in other countries. For example, in case of South Africa, they have a constitutional court. We have seen it, that we are recommending this regional benches idea because that is something which is well practiced in other countries. So the president of that constitutional court, they also have a human right court because they have been through apartheid and other such problem which is considered human right violation. So for dealing of these matters, they have a human rights court, and they also have a gender equality related separate court. So advocates from the gender equality court, human right court, constitutional court, these people are represented apart from obviously their prime minister and some council of ministers. So these representatives are there who decides the appointment. In case of United Kingdom, whichever is the name recommended, that is subject to the approval of House of Commons. See, this is not a namesake. But see, in India, if we even if we have such kind of provision, it will not make any difference. Because in India, in lower house, the government will always be in the majority. So whichever be the name, even if government suggests my name, it would be approved by the Lok Sabha. Only I should have the blessings of Prime Minister. But that is not true in UK. In UK, there is nothing like anti-defection law. In UK, people vote based on their conscience, based on their knowledge. That society, the politicians are much more civilized. So that's why there only if a person is having a person of integrity, a person of good experience, a person who is considered neutral is appointed, then only House of Commons is going to approve this name. And in USA, this role is played by Senate. For them, it is not the lower house which is the stronger house, it is the upper house, this is the Senate, which is a stronger house in case of USA. Okay. If CJI say for X yes, but 4 judges say no for X, then no is final conclusion. Am I right? Yes, yes, yes. Merely CJI cannot recommend the name either. The out of the other 4 judges, at least 2 should agree with the CJI. There has to be a majority. Then only a particular name would be recommended. So other suggestions, I will just mention it. This is something very obvious. Removal of SC like CAC, expenditure to be charged on Consolidated Fund of India, debar from any post-retirement job, cooling off period. See, we do not suggest that they should not join politics. We should not recommend it. Let them do the politics if they want. But they should not be able to do it immediately after their retirement. There should be a cooling off period of say 5 years. So even at the young age of say 70 years, if someone is interested in joining politics, he should be allowed. But not immediately after demitting office. Because immediately after demitting office, if someone is going to join politics, it is the same thing like saying that justice should not only be done, it should seem to be done as well. That person might act in a neutral fashion, but then people will raise fingers. People will point fingers that see you have taken some, you have joined that political party in the last election, probably you were not neutral. This is something that is happening. A judge of the Kolkata High Court, he resigned from the High Court and then contested election on the tickets of BJP. Obviously, his judgment is being questioned now. But probably you were not neutral in giving your judgments when you were in the High Court. Okay. And then the another suggestion which is given is that it should have an independent secretariat of its own. Especially nowadays that election is a regular phenomena. The Supreme nowadays what is happening that obviously it has few lower level bureaucratic staff, but most of its senior officers are on deputation from the state government or central government. So this is a recommendation that it should not be the IAS officers who are posted in election commission and senior officers. It should have a independent staff, independent hierarchy. Like we have various services are there. One election service should also be there. A dedicated election service should be there that that person would work in election commission throughout his career. We have Indian Information Service, we have Civil Account Service, Defense Account Service, Postal Service, have an election service as well. Why to depute the staff from central government? Obviously, they would be tilted, biased towards the government. Okay, is it clear? Any suggestions? Any doubt? Okay. Next, we are going to start the Representation of People Acts, the laws made by Parliament. So, we have two Representation of People Act. One is RPA 1950, another is RPA 1951. What is the difference between the two? This is something which deals with establishment of election, or rather you can say that election preparation kind of thing, and this deals with actual conduct of election. I will elaborate. What is meant by establishment of election? So to conduct election, you need to do the delimitation, You need to decide about the constituency. You need to have an electoral roll. So how electoral roll would be prepared, how delimitation would be done, what is the criteria to select the constituency, all those details are there. Who will do, what will do with respect to them. This is something with respect to that is there in Representation of People Act 1950. Whereas Representation of People Act 1951, it talks about conducting the election, who will be the candidate, what is going to be his qualification criteria, what is the disqualification criteria, what are going to be the corrupt practices, what are the practices which are allowed, what are the practices which are not allowed, what are going to be the electoral offences. So these are the things. How are you going to deal with the electoral disputes? So these are the things which are dealt in Representation of People Act 1951. So most of the time in the newspaper we see about these things only. Electoral roll, constituency, etc. Like we have seen this Representation of People Act 1950, it mentions that the award given by Delimitation Commission shall be final. It has said that it will have the effect of the law. It means that Parliament need not pass any separate law to give legal status to the award given by Delimitation Commission. Effectively, it means that Parliament cannot change the award given by Delimitation Commission. This is something that we have studied for Representation of People Act 1950. Obviously, we have also seen that the constitution says that any other qualification criteria as mentioned by a law of the parliament, that will be, and there we have seen the example of Representation of People Act 1951, that it says that a person to be eligible to contest election must be an elector, he must be a voter. Okay. So we have already seen examples at some places, but some specific provision we are going to see in more detail, because UPSC in past has asked questions in much more detail. A specific question, they have simply picked up the provisions of Representation of People Act and has asked a question. So we are going to see it in much more detail, and the first thing that we are going to study is election dispute. Okay, so now we are moving to Representation of People Act 1951. Not much is there to be studied in Representation of People Act 1950. Okay, now see why this election dispute. What is this election dispute? So again, we will go to the article number 329 itself, which says that courts are barred to interfere in the election matters except here, except by an election petition, okay, presented to such authority and in such manner as may be provided for by or under any law made by the appropriate legislature. So appropriate legislature will make a law. Accordingly, as per the law, election petition has to be filed, and only on that election petition the court can discuss the matter related to election. Okay, so it's that's why you might see that people, like when in election someone gives a very outrageous speech, some communal speech, people do not go to the High Court or Supreme Court. People go to the Election Commission under Model Code of Conduct. Okay, in today's Indian Express, there is a very good article by Yogendra Yadav on this, like he is recommending that we should do away with the Model Code of Conduct. Obviously, I would not say that we should do away with Model Code of Conduct, but you should read the argument given in that article. That's a very good article. So similarly, so in the next topic, like tomorrow, we are going to discuss the Model Code of Conduct as well. I will discuss that article as well, some of the points that is given in that article. Now, one thing is clear, that only election petition is allowed, and here it is said that under any law, and that law is again Representation of People Act 1951. So what is there in Representation of People Act 1951? We need to understand. Representation of People Act 1951 lays down a procedure to file the election petition. Okay, and it says that election petition can only be filed. First thing is that it will be filed after election. So only after election commission has declared the result, then you can approach the court. The first and foremost thing is this. Second thing is that it can be filed by a candidate or any of the electors. So suppose there is a dispute about the election of, say, Prime Minister Narendra Modi. So either the person who is contesting against Prime Minister Narendra Modi or the person who was an elector in that constituency can file an election petition. We who are not having any business cannot go and file an election petition. And then it has also said, okay, it is not written, that election petition, the appropriate authority, in the last article, it was mentioned that presented to such authority. So that authority has been declared as High Court. And it is High Court for both Lok Sabha election as well as a state legislative assembly election. In case of, say, president and vice president, it is the Supreme Court. For all other elections conducted by Election Commission of India, the respective state High Court has the jurisdiction. Okay. Do you know who has the jurisdiction with respect to the local bodies election? In case there is a dispute, you are not happy with, you contested the election of, say, Sarpanch, and you saw that there is malpractice. Probably I have been unfairly treated. I should have been winner. That other person has been declared winner. Where does lie the, and where can you go in the form of election dispute? Will you go to High Court, Supreme Court, or any other court? Is there any tribunal, etc.? Any idea? Any guess? So see, this is again an optional provision. It has been left to the state governments to decide where the election petition will file. Okay, like in my state, it has been decided, the state law in my state has decided that it would be the district court where the election petition would lie. In other state, it could be different. Okay, so it is not with a state election commission. There are courts only that has been designated, but some can have a magistrate court, some can have a district court, or maybe high court. Some state can decide. Probably in case of, say, Chandigarh, it is in Union Territory, it was the high courts, and that's why when there was a dispute in the mayor election of the Chandigarh, people directly approached the Punjab and Haryana High Court. But it could vary. Next is that the petition has to be filed within 45 days of the election. There is a time limit, and when obviously like more than one person has filed the petition, then all those petitions will be clubbed together to the, and it will be presented to the same judge, and there has to be a day-to-day trial. Okay, and the time limit have been given as 6 months. So effectively High Court would act like a fast track court where the trial would happen on day-to-day basis. Obviously, like within 5 years, there is going to be next election. So if High Court takes 5 years, which it usually takes for say concluding any case, it would have no meaning. That person has already completed his tenure. So that's why this provision has been made. And then High Court will follow definitely the Code of Civil Procedure, Indian Evidence Act, etc. Here see, this is again a difference. Like I have told you in the previous classes that high courts are a court of appeal, and when you go into the court of appeal, uh, it is appellate jurisdiction. Mostly the evidences, etc., are not presented afresh. It is always the arguments that take place in the high court when you go on appeal, or argument on the basis of evidences, witnesses that has already been examined by the lower court. Okay, so usually they deal with the application of law, but not in this case, because this is a original jurisdiction of the High Court. And the act also mentions that in this whatever be the proceeding methodology that High Court may decide, that nowhere the secrecy of voting should be infringed. It should not happen that in the judgment High Court has published that this person has given vote to this person and this person has given vote to this. Whatever be the procedure adopted, the secrecy of voting should not be infringed. And then in the terms of judgment, what are the options that the court have? The High Court can either dismiss the petition, it can say that okay, no merit is found, whoever has been declared winner is right, or it can declare the election to be void. It can say that election is null and void. There has to be in this case, there has to be a fresh election. The High Court has another option as well. It can declare any other candidate as winner. This is something that Supreme Court did in the local body election of the mayor election of the Chandigarh, that it declared some other person as winner. So that authority is there somewhere, like High Court if decides that okay, probably this person should not have been winner, the other person should have been the winner, it can declare the other person as winner as well. Another important provision, this is very important because you will very soon understand. There is also a provision that High Court order shall mention the finding of corrupt practices and name the guilty person. Okay, and this corrupt practices is obviously common sense, but we have to see what are the corrupt practices mentioned in RPA 1951. So RPA 1951 mentions a few corrupt practices. So in case during the course of trial the High Court finds out that there has been some corrupt practices, the High Court will find in its judgment and mention the guilty person. This is important because I will tell you later what is the significance of this. Okay, but do pay attention, do write it in your notes. Okay, and obviously if a cost is to be payable, the High Court will also mention the cost, the fine, etc. that is to be imposed on any other person. Okay, I will come back to this corrupt practices point again because in today's class itself we are going to see what are the corrupt practices mentioned in the RPA 1951. But suppose High Court has given a judgment. Suppose I was declared winner. Then High Court has said that no, I am not a winner. Probably my opposition member, that is the person who is winner. What are the options with me? The common sense suggests that obviously I should be allowed to appeal against the High Court judgment. Appeal to Supreme Court? Yes, that is the option which is there. Okay, no. Yeah, that is the option that a person can appeal to Supreme Court. And the RPA Act itself gives the ground as well on which appeal can be made, whether a question of law or fact. Okay, so on both the ground, a person can appeal to Supreme Court. And in fact, normally under appellate jurisdiction, you must have studied that it is the High Court that certifies that if the matter is fit for appeal or not. Something like which is open and shut case. Okay, like some cases are very much clear. There is no matter of doubt. In those cases, High Court says that it is not fit for appeal. It would be a wastage of time of the Supreme Court if the matter is taken on appeal. So a certificate of fit for appeal usually is given when there is a doubt. Okay. But here in these cases, from every order of High Court, the appeal will lie to Supreme Court. There is no need for certificate of fitness for appeal. And here also, like earlier there was time limit of 45 days, now the time limit of 30 days have been given. But obviously in this 30 days time period or 45 days, although this is a small time period, nothing much is gonna happen. But if that person in the meantime wants to say take the oath in say state legislative assembly or in Lok Sabha, and this might be important at some time because if he is able to take oath, he is going to vote for the confidence motion. It would be helpful in securing the claim for forming the government. So for that purpose, the person can also get a stay, and that a stay of operation of the High Court order can be obtained from High Court itself or from the Supreme Court. So that person can go to the Supreme Court without filing the appeal. He can simply go and say that please stay the operation of the order. I will file the appeal. But this also has to be done within 30 days. So within 30 days, either he has to file the appeal. If he doesn't, I mean, he can get the stay, he can file the appeal. Now, what are the grounds on which the election can be declared null and void by the High Court? So we shall see. And if you apply common sense, then also you can answer this question, that what are the grounds for voiding election? And this is something which is mentioned in 100, 100 you will call police, and in police you will say that election is void. So see, it is very simple. If you simply think from the perspective of what are the different steps in conducting election, the first step in conducting election is that the person is filing nomination, and that person, whoever is declared winner, that person must be eligible. He should meet the qualification criteria, and he should not meet the disqualification criteria. So this is the first thing, that you should be qualified and should not be disqualified on the date of filing the nomination. Second thing is that if you have filed a nomination, other people have also filed the nomination. So other people should, their paper should not be, I mean, someone who should not contest election should not be contesting election. I will tell you. Like, if someone whose nomination was improperly accepted, that is another thing which is wrong. That person, maybe a person was disqualified, maybe a person has filed the wrong nomination papers. If his nomination was still accepted, that could be a criteria for voiding the election. And other way around also, if nomination has been improperly rejected, like I wanted to contest the election, but my nomination was rejected by the returning officer, then I can say that, see, my election was improperly rejected, probably I should be allowed to contest the election is void. Then, if any corrupt practice has been committed by candidate or his election agent, this is the same wording, corrupt practice, again coming here. Last article also, last section also we have seen that High Court will mention the corrupt practice. Here also it is saying that corrupt practice can be a ground for voiding the election. So this corrupt practice becomes very important. And any corrupt practice has resulted the election. So this is something which may not be done by the candidate. This is something that is committed by the candidate. Then next is about the voting. People have voted. So if you have counted the bogus votes which were never polled, that could be a ground for voiding. Sometimes it may also happen that some votes which were properly polled but that were not counted, they were wrongly rejected. Like this is something that has happened in the mayor election of Chandigarh. So this can also be a ground for voiding an election, or any provision of Constitution or Representation of People Act. If there has been non-compliance, this is going to be a ground for voiding the election. Obviously, you got to prove in the High Court that all these things, it has resulted in, or it has impacted the outcome of the election. Like suppose a few votes were not counted, say 100 votes or 1000 votes of a particular polling booth has not been counted, but the margin is say 1 lakh votes. In that case, that is not the ground for voiding the election. it should have affected, like there has been a corrupt practices, a bottle of liquor was distributed. Now one bottle of liquor cannot impact the outcome of the election, so that cannot be a ground for declaring election as void. So it should be in that proportion that it has impacted the outcome of the election. Okay, have you noted it? There can be a direct question. I know it is a relatively boring to study these things. There are a lot many factual in nature. But if you systematically try to remember, first is about the candidate should be qualified. Second is about nomination, his nomination and others' nomination. Then about the conduct of election, corrupt practices, and then the counting of the vote, and then about the any other provision. Systematically, if you keep it in mind, you need not memorize it. This is something that we have already seen. Next is that qualification and disqualification criteria. In terms of qualification, there is a simple fact. There is only one qualification criteria that we have discussed. Or there are other criteria that if someone is contesting from the seat reserved for scheduled caste, he should be scheduled caste. If someone is contesting from a seat reserved for scheduled tribe, he should be scheduled tribe. So these are the very obvious in nature, not going to be asked ever, not even in prelims. There is no possibility. What is possibility to be asked is disqualification criteria. There is a lot of detail, nitty-gritties involved. So now give the heading disqualification under Representation of People Act 1951. So there is section 8 which talks about various disqualification criteria, and one disqualification criteria that all of us must have studied is someone who is sentenced for 2 or more years of imprisonment. This is something that was attracted by Rahul Gandhi when in the defamation case Rahul Gandhi was sentenced to 2 years of imprisonment, and because of which he became disqualified. But that's not the only disqualification criteria. Most of the student, if the question is asked, would end up writing only 1 point. In fact, there are certain offenses under those, if a person is convicted even for 1 day, or suppose if he is sentenced a 100 rupees fine, he will become disqualified just because of the nature of those offenses. And in certain offenses, the period is that minimum sentencing should be of 6 months, and then the rest of the offenses it is 2 years imprisonment. Okay, so there are three criteria. If a specific question is asked, UPSC will expect you to mention about these three criteria. First is section 8 subsection 1. It says that irrespective of the sentence, if you are convicted of any of these offenses, and these offenses, some of them, like the list is relatively longer, there are other offenses also. Some of the prominent one I have picked for you. Okay, that is section 153A of IPC. Still, like the sections of BNSS are not mentioned in the RPA Act. So still, I mean, that updation is yet to be done. It is still referring to IPC. We are also going to refer to IPC only, and you have to memorize 2 or 3 example only, not all. And some of the example you can very easily remember, like offenses promoting enmity between various communities on the basis of religion, caste, etc. So if a person is convicted for that offense, he will become disqualified even irrespective of the sentence. If someone is accused of offenses related to rape, or section 498A, it is about cruelty to your wife or cruelty to a woman by his husband or any other family members. Very often it is linked with the Dowry Prohibition Act, because this section was added along with that act. Okay. Protection of Civil Right Act. This is about untouchability. So if you have engaged in a crime against women, if you have engaged in promoting enmity, in untouchability, or Foreign Exchange Management Act, or Prevention of Insult to National Honor Act, or Prevention of Corruption Act. This is very important. So if a person is convicted under Prevention of Corruption Act, even for one day, that person would be immediately disqualified. Apart from that, there are few offences for which if imprisonment is of 6 months, like Dowry Prohibition Act. So now here you need to understand, Dowry Prohibition Act is a separate act and section 498 is a separate prohibition. Okay. And hoarding or profiteering and adulteration. These are only 3 provisions, so that's why I have written all 3. There are other provisions also in this act, but important one I have brought. So in this case, when you are engaged in adulterating, profiteering or hoarding or Dowry Prohibition Act, minimum 6 months of imprisonment should be given to you. In that case, you will become disqualified. And in case of any other offence which is not mentioned in 8.1 or 8.2, the minimum requirement is that you should be at least getting 2 years of imprisonment. So that's why in defamation case falls in this third category. Even if Rahul Gandhi was given a sentencing of 1 day less than the 2 year, like maximum imprisonment is of 2 year in defamation case. Even if he was sentenced for 1 year, he would not have attracted disqualification. Okay. And in all these 3 cases, the period of disqualification is 6 years after completion of sentence. So suppose a person was sentenced in 2024, he went on appeal, and then the matter went on subsequent appeal to High Court and Supreme Court, and then the matter came to a finalization in 2034. Supreme Court said that no, you are still guilty, and Supreme Court sentenced him for 6 years. So from 2034, he will be in jail till 2040. After 2040, he would be further disqualified for 6 years. So he would again be eligible to contest election only in 2046. So that's why it is said that often once you are convicted of any offense, probably your political career is over. Because obviously you are not going to accept your conviction immediately. You will go on appeal. After going on appeal, you have to complete your sentencing, and then further 6 years you will remain disqualified. Now here the problem was that what is the normal practice that when you go on appeal, like lower courts had sentenced you for whatever be the quantum of sentencing, if you appeal to High Court or you go to the Supreme Court, our legal system is made of the presumption of guilt, that unless you are proven guilty, you are considered innocent. And so High Court, what it does is, first of all, it removes the conviction. It says that in my court a person cannot come as guilty. In any court a person will only enter as accused, not a convicted person. So High Court first of all removes the conviction, and since the conviction is removed, when a matter is in appeal, the conviction is removed, the person becomes eligible to contest election. This is something that has happened with Rahul Gandhi. When Rahul Gandhi went on appeal, the High Court has removed the conviction. Although High Court has not removed the conviction, it is the Supreme Court that has removed the conviction in Rahul Gandhi case. So since the conviction has been removed, now he is again eligible to contest the election. And this is the normal practice most of the time happening. So like what I am saying, that this time period 2024 to 2034 people were on appeal, and on appeal no conviction has been removed. So that's why they were in this time period they were eligible to contest election. So effectively this disqualification provision is not having meaning, because the matter would remain in appeal for 10 years, 20 years, till the time he becomes old enough to not contest the election. So that's why the Supreme Court gave an order that in the matters of Prevention of Corruption Act, the High Court will not remove the conviction. Since corruption is something which is a crime, which is a serious crime, which is something which is bringing about a lot of disrepute to the public life, that's why Supreme Court said that in Prevention of Corruption Act, High Courts will not remove the conviction. So in Prevention of Corruption Act, if you are disqualified, if you are sentenced for even a single day, then your career is finished. Is it clear? So suppose you commit a murder. In that case, when you go on appeal, your conviction would be removed. You can still contest election. But in case you have committed corruption, then on appeal, the court is not going to remove your conviction and you are debarred, you are disqualified from contesting election. Is it clear? Is there any doubt? There are other points also in this disqualification. Clear? Okay. Apart from that, there was also a section 8(4) which used to mention that suppose a person is already a sitting MP and MLA and he is convicted under either of these of section 8(1) or 8(2) or 8(3), then he would be disqualified. So it had given him a time period of 3 months. So 3 months time period was given to sitting MP or MLA. So he would be subject to disqualification after the 3 months time period if he is already a sitting MP and MLA. So this was the time period given to sitting MP and MLA. In this time period they can go on appeal, and if in that appeal period the conviction is set aside, then he would never be disqualified. If conviction is not set aside, then after 3 months he would be disqualified. This was the provision given in Lily Thomas case. In Lily Thomas case, Supreme Court declared this provision as unconstitutional. So Supreme Court declared section 8(4) as unconstitutional. Supreme Court said that it is violation of right to equality. This is another example you can have as electoral reforms being done by the Supreme Court. I will do the compilation. In Lily Thomas case, Supreme Court said that this provision 8(4) is unconstitutional in nature. Why? Because it discriminated between those who are MP MLA and those who are not MP MLA. And this is not a reasonable classification. So it is violating the right to equality. It is arbitrary. So it is unconstitutional. I will repeat. Supreme Court said in Lily Thomas case that section 8(4) of RPA Act 1951 is unconstitutional because it is discriminating between those who are MP MLA and who are not. This discrimination is arbitrary in nature, so it is violation of right to equality. That's why it was declared unconstitutional. Is it clear? Next, we have few more grounds for disqualification. There is a long list for disqualification. There is also a section 8A which disqualifies on grounds of corrupt practices. This is coming again and again. What are these corrupt practices? Okay. So obviously, if someone is accused of or ground of corrupt practices, well, that person need not only be accused, that has to be declared by an order of court. So that's why, see, that's why it was required that on an election petition, the High Court will declare the name of the person who are found guilty of corrupt practices. Because once a person is found guilty of corrupt practices, he is also subject to disqualification. What are those corrupt practices? We shall see. But you understand the logic behind the provision which was given over there. The provision on election dispute. Okay. Now, he is considered guilty by an order of a court. In this case, this court is High Court usually, because High Court on an election dispute, this is going to give an order that this person is guilty. Okay, but in case of corrupt practices, the quantum of disqualification is decided by President. In earlier cases, the quantum of disqualification was fixed, that is 6 years. Here, what is fixed is only the maximum quantum of punishment, that is not more than 6 years. The person, in case a person is found guilty of corrupt practices, he is not disqualified for 6 years. Rather, he is disqualified for a period less than 6 years, and that is to be decided by President. Obviously, President has to act on advice of Election Commission. And obviously, like other cases, the advice of Election Commission is binding on President. President cannot use his discretion. He is not supposed to use either. Okay. Next is there is section 9. This is disqualification for government servants for dismissal for corruption or disloyalty. If a government servant is dismissed, so suppose you become IAS officer and then if you are dismissed from the service for corruption or disloyalty, then you cannot say that, okay, now that I have been dismissed from the service on grounds of corruption, I have the necessary qualification of a politician. Now I will contest election. That is not allowed. You are also disqualified to contest election for 5 years. I mean, I don't understand the logic of having different numbers. Why could not you have kept it simple? 6 years, like it was there in 8.1, 8.2, 8.3. Okay, but see, this is probably the burden that they want to give us more than us. It is the legal services people who are burdened by these provisions more. So, in case of the government servant, the period of disqualification is 5 years. Next, disqualification for government contracts and disqualification for office under government company. So, if a person is already having a government contract or if a person is holding office under a government company, that person is also disqualified. So that's why you might have seen that people usually resign from the government job, then they contest election. Obviously, this is something in the nature of not allowed to have office of profit. This is extension of that provision only. I'm not saying that this is exactly office of profit. This is an explicit provision. Office of profit is not defined. Here office of profit word is not used, but effectively this is that kind of provision only. And here there is no period of disqualification. As soon as you demit office, you become eligible. So if a person has taken a contract, as soon as the contract comes to an end, that person becomes eligible. Logical. If you are in government job, you resign. Like Mr. Fazal, who had got IAS rank 1, who was in Jammu and Kashmir, he resigned from IAS, contested election, then he again joined back the IAS as well. Okay. Next is section 10A, disqualification for failure to lodge election expenses with Election Commission of India. This is also something which has been added later on, that in case all the candidates are supposed to maintain due diligence of all the expenditure that they are doing. So if you decide to contest election, you got to open a separate account, and using that bank account only, you have to do your expenditure, and you have to file the detail of all the expenditure you did with the election commission. Why this happens? Because there is a limit of expenditure that you can do in any election. Do you remember that limit? Please mention in the chat section. I will tell you later on. Then, okay, in this case, the disqualification is for 3 years. Again, another number. So now we have three different period of disqualification. First was 6 years. Then there was a period of 5 years. Then there is a period of 3 years. And then there is also a provision for less than 6 years. 6 years, less than 6 years, 5 years, and 3 years. 3 years in case you have not lost the election expenses. Okay. See, this is also something which is meaningless, because what practically happens, that those people who fail or other who do not win the election, what they do not file their expenses. It is only the winning candidate who file the expenses. Even if someone is disqualified for 3 years, the next election is going to happen only after 5 years. So probably this disqualification should be increased from 3 years to at least 6 years level again. This is a recommendation that you can write. That as of now, this is 3 year only. Then another provision that has been given, that a discretion has been given to the Election Commission of India for removal or reduction in the period of disqualification. So like, if for any reason Election Commission of India is convinced that probably he needs to be disqualified for a lesser period of time, not for 6 years, maybe for 2 years, 1 year. So this power has been given to Election Commission. Again, for corrupt practices, it is not allowed. If someone is engaged for corrupt practices, then in that case it is not allowed. Why it is not allowed? Because in corrupt practices, it is the Election Commission only which has decided the matter, that you would be disqualified for something less than 6 years of disqualification. So again, Election Commission should not be bogged down with the same repeated request of looking into the matter of disqualification. So that's why in case of corrupt practices, the person will not be, there is no provision for removal or reduction of the period of disqualification. In other cases, the power has been given to Election Commission of India for stating the reasons. In written, Election Commission of India can reduce the period of disqualification. Okay. Is there any doubt? That's all that we have. So first, like we had three provision, 8.1, 8.2, 8.3. They were attracting 6 years. Then we had less than 6 years. It was 8A for corrupt practices. Then we had 5 years. It is for government servant. Then we had 3 years. If you do not lodge expenses. Then we have disqualification like office of profit. Like what I should say, it is for 0 years. As such, there is disqualification till the time you are involved in such things like government contract and office under government. These are the different type of disqualification involved. Okay, I expect a direct question to be asked on this. Like we have had a direct question on election dispute where UPSC directly asked that what is the procedure involved in dealing with election dispute and what are the remedies available. And exactly Representation of People Act have this terminology only, procedure and remedies. So similarly, This is the heading of disqualification. Exact question can be asked. If you have any doubt, please ask. It may be a little difficult. I have tried to make it a bit systematic for you so that you are able to memorize it. But it will require some amount of effort on your part. Next is, we have been listening to these corrupt practices. If someone is accused of corrupt practices, he would be disqualified for a period not more than 6 years by President on recommendation of Election Commission of India. We have also seen that who will declare that someone is accused of corrupt practices? It would be declared by High Court on an election petition. Now we need to know what are these corrupt practices. And the first thing is that probably ordinance is the corrupt practice. Why? Because it is mentioned in section 123. Ordinance is mentioned in article 123. I am telling you just so that you remember it easily. Ordinance is not a corrupt practice. But yes, we know that re-promulgation of ordinance is fraud on constitution. That is something said by Supreme Court itself. In which judgment? Please mention the judgment. In which judgment Supreme Court said that re-promulgation of ordinance is a fraud on constitution? So you can remember the section 123 mentions the corrupt practices under RPA 1951. Now what are those corrupt practices? First is obviously corruption, means we understand bribery, and here bribery to, there could be a bribery to a voter. Like in election, a lot many people become rich as well. They get 1000 rupees, 2000 rupees. Some people enjoys, what do you say, foreign liquor only on the eve of election. Then there could be bribery to a prospective candidate as well. Prospective candidate or a candidate. Suppose money is given to a person to contest election. It might happen. There are vote katwa that we call, that vote cutter people who actually have no possibility of winning the election, but they will get enough votes so that someone else can lose the election. If money is given or any other undue benefit is given, gratification is there for this purpose, this is also a kind of bribery. So this is also comes under corrupt practices. Next is undue influence of voters. Suppose like it may happen, someone goes with a rifle on the polling booth and did not allow the voters to vote. This is also a corrupt practices. If you appeal on the ground of religion, race, caste, community, language, etc., I belong to religion A, you also belong to religion A, then you should vote me. I belong to a particular caste, you also belong to the same caste, then vote me. If such things are done, that is also a corrupt practices. And if something like it is promotion of enmity or hatred on the grounds of religion, race, caste, community, language, that is also a corrupt practices. Publication of false statement about personal character or conduct of a candidate. It is very often happens now that, see, you know that person has 3 wives or 4 wives. If such personal character assassination is done, which is false in nature, that is also a corrupt practices. Next is hiring a vehicle for free conveyance of an elector to polling booth. This is also something you must have noticed in your local election. Usually, like in local election in my area, it happens. The one of the candidate will send us vehicle to our home, so that those people who are living in urban areas, they have their name in the villages, the electoral or in villages, they could commute. Otherwise, they will not bother to vote. So what is done, that they are facilitated so that they go to the village, cast their vote. This is also an example of corrupt practices. And then if someone is incurring expenditure more than the prescribed limit. Okay, what was the prescribed limit? I just asked you, you did not reply. So please write it down. See, the states have been categorized in two categories: larger state and a smaller state. And limit is obviously different for Lok Sabha and a state legislative assembly, because in Lok Sabha the size of the constituency is large, in a state legislative assembly the size of the constituency is less. So for larger state the limit is 95 lakhs and 40 lakhs. Whereas for a smaller state the limit is 70 lakhs and 28 lakhs. Sorry, it is 75. So looking at these numbers, probably you can think that you can also contest elections sometimes. I don't know if many of you, how much rich you are, but see, these numbers are no reflection of the actual expenditure done. In actual, these are numbers are usually in crores. Without spending 30-40 crores, you cannot expect to be in the contest either. Even to be in the contest, I mean, because everyone is just spending in that tune only, to the tune of 40-50 crore, sometimes even more. Okay, and this is something which is spent by in addition to the expenditure done by political parties. Like see, in electoral bond itself, BJP has got around say 6,000 crore rupees. So if like 543 constituency, even if on all the constituencies BJP is contesting election, it has got only through electoral bonds. Mind it, this is not the complete expenditure. If they are getting 5,000 crore rupees, see, per constituency 10 crore rupees they are getting. Okay, this is just BJP, and this is the number you can see, only lakhs, less than 1 crore is the expected expenditure. So obviously there is no synchronization. This is more of a theoretical in nature, but again, theoretically this is a corrupt practice. If someone does more than this expenditure, and he would be disqualified for a period to be decided by president. Okay, obtaining assistance from government servant, this is also very important. If someone obtains assistance from the government servant, it could, I mean, the range of public servant are mentioned, even judges, etc. If they are involved, this would be considered as corrupt practices. And obviously booth capturing. If you are not allowing people to vote, if you have voted rigging, another name for booth capturing is rigging, that is also a ground for corrupt practices. So this is mostly common sense. It's just that you have to apply your mind. You can understand that okay, these are the corrupt practices which could be there. Okay. Any doubt? Now we shall move to next topic. This is very simple. This is simply because it is mentioned in the RPA Act. I am bringing it to you. Like vacation of seats, you must have already studied. We have already covered it as well. Like suppose a person wins election to both the houses simultaneously. He, he is given 10 days time to communicate to Election Commission of India that which of the two seats he is going to occupy. If he does not communicate, his seat in Rajya Sabha becomes vacant. This is something which if he is elected simultaneously. In case he is already a member of one house and he gets elected to another house, in that case, what will happen? That seat in the present house becomes vacant. This is on the premise that obviously he wanted to go to another house. That's why he was contesting election. So his seat in the first house should become vacant. Then, if he is elected to more than one seat to the Lok Sabha or Legislative Assembly, this is something that we have discussed in the class earlier. In that case, he have to communicate within a specified period to Election Commission of India, else both seats become vacant. Okay, so this is something that we already know, and this is something which is about common sense as well. If he is in both houses, Lok Sabha is more important. So his seat in Rajya Sabha should be vacant. If he was already a member of one house, elected to another house, the first house should become vacant. In case he has won from more than one seat in the Lok Sabha, now there is no logic that which seat he should occupy. So in case he does not communicate to Election Commission that I am holding this seat, the another seat will be vacant. Like Rahul Gandhi has declared that he is keeping the Raebareli seat and he is quitting the Wayanad seat. So the Wayanad seat is going to bypoll again. In case he did not communicate in time, both the seats would have become vacant and Rahul Gandhi would not have remained the MP. Okay, obviously it's just writing a letter, everyone does it in time. Then the one small thing that I am just giving you a compilation, that Supreme Court has also given various judgment that has helped in electoral reforms, or that has helped in what to say, strengthening the roots of democracy in our country. Okay, this is something, one of the benefits of what to say, judicial activism. Also we have seen that electoral reforms are one of the benefits of judicial activism, because obviously parliamentarians being involved in this electoral practice, they are not expected to engage in electoral reform. So this is the work which has to be taken up by the Supreme Court only. So Supreme Court has given some judgment. One of the judgment today only we have discussed is the judgment in Lily Thomas case. Okay, this is something that we have discussed. It is not 89.4, it is section 8.4. Section 8.4 of RPA 1951. The first was ADR versus Union of India case. This case has given, we have discussed this case as well, in which it was declared that RTI, right to information, is part of Article 19 as fundamental right. Do you remember that the freedom of speech and expression, the Supreme Court said that to give your expression, you need to have information. Without information, it will not make sense. Okay, and the Supreme Court also said that when see, very brilliantly Supreme Court has interpreted. Supreme Court said that okay, a right to vote is a constitutional right, not a fundamental right, because it is mentioned in Article say 325-26. But when a person is voting, the act of voting is an act of expression. When a person is voting, he is exercising his freedom of speech and expression. And to exercise his freedom of speech and expression, he need to have information. And that information is part of, so from there the Supreme Court said that right to information is part of Article 19, is part of fundamental right. And so Supreme Court said that every candidate in its affidavit must declare its assets, liability, educational qualification and criminal antecedent, criminal background. If any case is filed against him, if he has been convicted or not, he must give all this detail. Next is in this PUCL versus Union of India case 2013, right to vote includes right to reject. From here, the nota was installed on EVM. The nota button came on EVM because of this judgment. Okay, and see, this PUCL, People's Union for Civil Liberty, and ADR, Association for Democratic Reforms, this is another, these are the examples of NGOs or civil society. So in governance paper, when you have to give examples for NGOs etc., then also you can quote these judgment, like NGOs are bringing about electoral reforms. So one example, multiple uses. If a question is directly coming on Supreme Court, judicial activism, then also you can say. If your question is coming on electoral reforms by Supreme Court, then also all these things. Question on NGOs, few of the judgment, you can mention it. Okay. Next is Subramaniam Swamy versus Union of India case 2013. Through this, Supreme Court gave an order that VVPAT should be used. VVPAT, I hope you know, voter verifiable paper audit trial. So like if you have given the vote in recent time, you must have seen that when you press the button, then the candidate to which you vote and the symbol, party symbol, etc. is printed. It remains in front of you for approximately 5 seconds or so, and then it is deposited in the box which is attached. So in case there is a dispute that probably I voted to BJP, I voted to party Congress and then the vote went to BJP, this is something which was happening earlier, you can count the paper audit trail, the slips can be counted and it can be ascertained that actually no, whichever candidate the people voted, the vote went to the same candidate. Okay. This is again Anup Bandwal case. We have already seen appointment of CEC and Election Commission. Supreme Court made an attempt. Supreme Court made an attempt to bring about electoral reform. Obviously, it was nullified by the Parliament or the government. But well, Supreme Court must be applauded for bringing about this, making this effort, bringing about these reforms. If you have any doubt with respect to any of the judgment, please do ask. You must, like these are the 5 judgment, you must remember them on your tip. Any point of time, even at 2 a.m. in the morning, someone wakes you up from the uh, deep sleep and asks you what is the Lily Thomas case, you must be able to say. Okay, but these are very important judgment. It must be on your tip. Any doubt, you must ask. Either you can ask it now or you can later on also ask it by giving your comment in the comment section. The class is going to an end. No doubt. Okay then, so that's all that was there in today's class. You can connect with me in any of the social media sites. My username handle is same, Madhusudan_IIT, and I would be happy to connect with you. I will happy to give reply. There is a doubt, sir. What is significance of nota? Okay, I will tell you. See, as of now, nota has a statistical significance. Why I am saying it as a statistical significance? Because see, people can debate or a research can be done as to whether the people's satisfaction with the candidates are increasing or decreasing. If a large number of people are voting for nota, it means people are probably dissatisfied with the choices they were presented with. Okay, but as probably the background of understanding of your question is that even if nota gets maximum number of vote, suppose there was an election conducted and say nota got 1 lakh vote and the other candidates have got, say Mr. A has got 90,000 vote, Mr. B has got 50,000 vote, and so even in this case, like nota has got the maximum vote, since the among the actual candidates, Mr. A had got the maximum number of votes, Mr. A would be declared winner. It is not that all of the candidates would be rejected. So effectively, you may write it down, effectively, we do not have right to reject. So that's why probably you are asking this question, that there is no real significance of nota, but the significance lies as of now in a statistical analysis, in analyzing the quality of our democracy. And it is definitely like those people who feel that none of the candidates are good, they also have a medium of expression. So it is giving a mode of expression, to the disillusioned people. Even if I am disillusioned, I am not happy with the choices, I also have got a mode of expression. And maybe in future it would be a background for bringing about right to reject in our country. Suppose a lot many people start exercising, this can be a ground for bringing a right to reject in our country. Okay, is it clear? So that's all. We shall see. We shall meet again in tomorrow's class, the same time, 2 p.m. Till then, take care. Even if you are planning to burst crackers, do burst it safely. Okay. And in case you are living in any polluted region like NCR, I would advise you to refrain from bursting crackers. Okay. Stay safe. Happy Dhanteras. See you again tomorrow, 2 p.m.